Today in this lecture we will continue to see the charitable trust. When we see the charitable trust in our previous lectures, we have seen section 99 of the Trusts Ordinance. Section 99 of the Trusts Ordinance provides that then the expression charitable trust includes any trust for the benefit of public or any section of the public within or outside Sri Lanka of any of the following categories. A. For the relief of poverty. B. For the advancement of education or knowledge. C. For the advancement of religion and maintenance of religious rites and practices. D. Any other purpose beneficial or of interest to mankind not falling within the preceding categories. Now when you read this section, we can understand, even we have studied in our previous lectures, there are two matters we must prove. The first one is if a trust created by somebody, then first of all it should be a charity. Then the second requirement, it is for the benefit of public or section of the public. Then for the purpose of identifying charity, as we have seen in this section 99, it is defined or it is limited to certain matters. ABC, the paragraphs ABC specify certain categories: relief of poverty and advancement of education and knowledge, advancement of religion or maintenance of religious rites and practices. But the paragraph D is open in the sense anything and everything can be brought under this section paragraph, but it should be beneficial or beneficial to the mankind or interest to the mankind. Then these are the system we must prove that. The first place we must prove that the matter whatever specified in the deed of trust falls within the category specified in section 99 subsection 1. In addition to that, we must prove that it is for the benefit of public or section of the public. When we see that if it is for the benefit of public, there is no doubt that's for the general public. But when you talk about section of public, sometimes it may be confused with a group of individuals. That also we have seen when we study the benefit of the public or any section of the public. If there is a connection between the author of the trust and the beneficiaries, then it may be private trust. It is not the charitable trust. And also we have seen that when you talk about these benefit of public or section of the public, sometimes there may be some connection between the author of the trust and the beneficiaries by way of blood or by way of contract or by way of association or anything. But whatever it is, we must consider that whether it is for the benefit of general public or whether it is benefit to the individual some or other way connected with the author of the trust. Then if it is connected with the individual or relations of the author of the trust, then it is known as private trust. It is not charitable trust. But in Sri Lanka it is not the big issue, but still for the purpose of identifying whether the trust is charitable trust or not, we must see whether the trust satisfies the qualifications or the criteria or requirements specified in the Act. That is, there are two things we must consider. First one, whether it falls under categories given under section 99, and plus we must consider whether it is for the benefit of the public or section of the public. But in the case of individual also, we must consider if they have some sort of connection with the author of the trust, then we must say that it is not charitable trust. But it doesn't mean that it is not a valid trust. It is a valid trust, but it is not a charitable trust, but it is known as private trust. That we have studied. Now today we must start studying these different heads given under section 99. The first one given trust for the relief of poverty. Now first of all we must define what is known as poverty. That's a difficult thing because everybody will say that they are poor. Then how to identify who is poor? That's why we will see these slides here. The poverty means, or poverty may mean, different things to the different people. Now once we may say that in old days, about 50 years ago, the essential item known as accommodation, food and everything. Nowadays it has gone out of that. Now it's sometimes television, Wi-Fi, that also may be a essential thing, because for the education and everything it is essential to have a Wi-Fi. If you don't have Wi-Fi connection, sometimes you may be categorized as poor. That's why here poor may mean different things to different people. Those who have wealthy but are no longer so may regard themselves as poor, even though still comparatively well off, because they have their accommodation, they have enough for their food and everything is there, but they don't have Wi-Fi. That's the only thing, there's a short, but still they may be categorized as poor people. Support for this relative approach is to be found in the words of Sir Raymond in this case. Now, what he has said here, poverty does not mean destitution. That's very important. If you give something to somebody for food or whatever, then it may be regarded as relief of poverty. That's why poverty does not mean destitution. Nothing. We don't have nothing. Then only we must be categorized as poor. No, not like that. In some cases, they have something. They have the accommodation. They have enough. Therefore, their food, but still they are poor. That's why here poverty does not mean destitution. It means the persons who have to go short. That's very important. Go short is one of the essential element to check whether they are poor, due regarding being had to their status in life and so forth. 2 points may be elucidated from this statement. The first one, a person may in legal terms be poor without being entirely without means, because they have some sort of means to survive, but still they are poor. Then if you do something, if you create a trust for the benefit of those people, those who have accommodation, those who have enough for their food, but still it is relief of poverty. That's why here a person may be poor without being entirely without means. That's why the first one also in the first sentence specifically says like that. Poverty does not mean destitution. And the term is wide enough to embrace everyone who does not have enough. Does not have enough. That's the thing. Then there must be some limit. Then if it is necessary for that person, but he has such facility, then he becomes a poor fellow. Right, then here we can see the relief of poor must not be relieved to the body of private individual. That is a place we are going to test the public benefit or the section of the public benefit. That's generally, as we said, it should be for the benefit of public or section of it. Then only it is recognized and approved as charitable trust. But here, when you see this the case, the relief of the poor must not be relieved to the body of private individual, but must have a public character. Then always, if anything done to the private individual by name, then it is known as private trust. It doesn't mean that the trust is void or invalid, but it is a private trust. The relief of a group of individuals like poor relations of donor, poor employees of a company would not amount to the charitable trust. Even in the Oppenheim case, we have seen that the number of beneficiaries more than 110,000, but still the court held that that was not charitable trust. But here, the relief of group of individuals, like poor relations of the donor or poor employees of the company, would not amount to the charitable trust because there is a lack of public benefit. The trust for the relief of poverty form a major exception to the usual rule as laid down in Oppenheim, because that's the main turning point we must consider. Because generally we say, when we decided, we have seen so many cases, if there is a connection to the author of the trust and the beneficiary, then it can't be charitable trust. But here we say that trusts for the relief of specifically this head, the paragraph A of subsection 1 of 99, trust for the relief of poverty forms major exception to the general rule as laid down in Oppenheim case. The courts have long accepted so-called poor relations exception. Poor relation exception, even though the trust is created for poor relations, it is charitable trust. That is the exception to the general rule. But general rule, if the trust is created for the benefit of some individual or relationship, within the relationship, then it is not charitable trust. But in the case of trust for the relief of poverty, the court accepted that so-called poor relation as an exception to the general rule, whereby a valid trust can be established for the relief of poverty among the settlers' poor relations. Then this is the deviation from the general rule of public benefit. This is valid so long as the class of beneficiary is not further restricted. For example, a group of named relations. If there's a relation, poor relations, if the settler created a trust for the benefit of poor relations, that's fine. That's charitable trust. That's an exception to the general rule. It is accepted as charitable trust. But if the trust is created to the relations named in the deed of trust, then it is not a charitable trust, it is a private trust. Question was reviewed in Dingle versus Turner. This is also one of the important cases. Dingle versus Turner is more or less similar to Oppenheim case. A trust was established for the benefit of poor employees of the Dingle and Company Limited. At the time of testator's death, the company employed over 600 persons. Moreover, there were many ex-employees. the court held that trust was charitable. Now, because the reason behind this one, there is no individual named, but this is a group, poor people or poor employees of such company, Dingle and Company Limited. That's why it's not that specifically given the name, but it is a group of people. But generally, if there's a connection with the author of the trust and the beneficiary, then it can't be charitable trust. But here it is charitable trust because this is an exception to the general rule. The trust for the relief of poverty requires different tests from other forms of charitable trust which did not require public benefit. A trust for the poor relations or poor persons may take effect as private trust rather than as a charitable trust, As the distinction is as the matter of construction, whether the gift is for the relief of poverty amongst poor people of particular description, or merely a gift to the poor persons, particular person, for the purpose of relieving poverty among them. In the former case, the trust will be charitable. In the latter, it will be private trust. The difference between those two circumstances. The first circumstances, what we have identified, the trust is created for the particular description. Poor relations, poor employees. That's a description, not named. But the other one is merely a gift for the particular poor person. Then the name or names of the person given in the deed of trust. In that case, it can't be charitable trust, but it shall be a private trust. The essential difference between charitable trust and private trust in this area is between the gift for relief of poverty amongst the poor people of the particular description, which is charitable, and gift for the particular person, relief of poverty, being motive of the gift, which is not charitable, but that is known as private trust. A gift for the relief of poverty in the particular class of relations could be charitable because it recognizes the group or the description of the particular description, but not the name. But if the name given, then it can't be. But in this case, the class named as relations of my son and daughter. Relations, then it is a description, particular description, not the name. It appears even a selected group of relations may qualify in this light of resettlement. In that case, the test is a listed sum, that means he has given some name there, but not all of his siblings, and stated that they, together with their issue, formed the class to be benefited. Then there again description of group. Accordingly, there might be circumstances where a narrow beneficial class, such as employees of firm, relations of individual, is sufficient section of public for the relief of poverty. But general rule is not like that. If the trust is created for the employees of a firm or relations of individual, it is not a charitable trust because it is not for the section of public or the public. It is for the private individual, therefore it is a private trust, not the charitable trust. But in the case of relief of poverty, it is approved, or it is known as charitable trust. That's why we say that this is a relief of poverty, is an exception to the general rule. Finally, we will see this case, Commissioner of Income Tax versus the trustees of Abdul Ghaffur Trust. A trust for charity once a year during a month of Ramadan was held to be charitable because of the significance to the Muslims of the month of Ramadan and their practice of distributing alms to the poor during that month. The trust was regarded as one for the relief of poverty. But here, generally when you see this case, this is for the general group, but section of the public, because it is for the Muslim people. Maybe for the Muslim, the month of Ramadan, they do something for giving some distribution of alms and everything. Then it is known as relief of poverty. Then it is a charitable trust. Now what we have studied up to now, it is very clear. Trust for the relief of poverty is an exception to the rule of public benefit. Now we will see the trust for the advancement of education and knowledge. As we have seen in UK Charities Act 2011, their trust for the advancement of education is recognized, not the knowledge. But here in Sri Lanka, the trust for the advancement of education plus knowledge. Now first of all, we will see what is known as education. Education is anything and everything education. No, there are some limitations, there are some restrictions. When applied to young, it is complex and varied. It is a balanced and systematic process of instruction, training and practice, containing spiritual, moral, mental and physical elements. That's known as education. It may be assumed that anything which forms part of normal educational process and which can be said to fall within that definition will be regarded as education. That any trust for the advancement of such thing will be charitable, subject to the requirement of public benefit. The courts will reserve to themselves the right to exclude the things which they regard as harmful. You can't bring anything and everything into education. It may be for the promotion of knowledge, but whether the knowledge is for the good thing or bad thing, that the court will decide those things. Ultimately, if the knowledge is for the bad thing, then the court will say that's not a charitable trust. That's why here the court will reserve themselves the right to exclude the things which they regard as harmful. Herman J. in Riso case 1957 stated that schools for prostitutes and pickpockets would not be regarded as charitable. Attempts to disseminate political propaganda, that's again under the guise of education, have been consistently rebuffed by the courts. If the government takes some policy decision on the matters, then the union or the education institutions or the university should not go against the government decision, because it may be against the political will, or sometimes it may be against the political idea or ideology. That's why here we say that we must identify those things. If it is a political propaganda, then that should be stopped. That cannot be charitable trust. That's why in this case, similarly, educational charities will be restrained from using their resources for political purpose. That's fine. Baldry versus Faintuck, 1972 case, Sussex University Students' Union, a registered charity, was restrained from spending money on the campaign to restore free school milk. Since this way, an attempt to challenge the government policy, it was regarded by the courts as political, not charitable. Then here we will see, what about the research? Research generally promoting knowledge, but there may be some condition. You can't do some research which are not useful to the society. That's why McGovern versus AG, 1981, All England Law Report, the courts said that or stated that a trust for the research will ordinarily qualify as a charitable trust if, but only if, subject matter of the proposed research is a useful object of study. That's very important. It should be useful to the public. Then only the research work will be recognized as charity. The second condition, it is contemplated that the knowledge acquired as a result of that research must be disseminated to the others. Finally, the trust for the benefit of public, or sufficiently important section of the public. Second, in the absence of contrary context, however, the court will be readily inclined to construe a trust for research as importing subsequent dissemination of the results thereof. We must be very careful in this matter because there are some instances. Now, so suppose if you are a university student, or if you want to do your LLM or master LLM, or sometime maybe PhD in law, you must submit dissertation or the thesis in relation to your topic, whatever you have selected. In that point, the university will appoint supervising officers or supervising staff, and you have to discuss with your supervisor. You have to do your research and submit your dissertation. Once you submitted your dissertation to the university, that is, you can't publish it. Until otherwise, the university approves that to be published. Because prior to prior to the publication of such thesis, you must get approval from the university. That is one of the requirements in all over the world. Then in that case, if a person creates a trust for the purpose of research of something somewhere, then in that case, if the university student, if they do some research in relation to the university, then there's a problem, there's an issue might come, that whether you can give the result of the outcome of the result to the public. If you are able to release the outcome or the results of the research to the public, then it is charitable. Otherwise, it can't be a charitable trust, but it may be a private trust. Furthermore, if a trust for research is to constitute a valid trust for the advancement of education, it is not necessary then these are not necessary things. What are the things? Teacher-student relationship should be there, not necessary at all. The second thing is, person to benefit from the knowledge to be acquired should be a person who are already in the course of receiving education in conventional sense, not necessary at all. In this advancement, in the case of advancement of education, unfettered English precedents, the Sri Lanka courts are free to hold that research and learnings, at least in the scientific subject, are unquestionably in the public benefit. Then there is no second word. If there is a research for in the scientific subject, then it will be recognized and approved as charitable trust, because it is for the benefit of public anyway at the end of the research. Falil Kafur versus Commissioner of Income Tax. The trust was for the educational purpose, and recipient of the benefit were deserving youths of the Islamic faith. The primary disposition of the trust income was in favor of family of the grantor. Then limited primary disposition of the trust income was in favor of family grantor. Then it was not charitable purpose or charitable trust. The Supreme Court of India has, however, confined the meaning of word education to connote the process of systematic instruction, developing knowledge, skill, mind and character of students by formal schooling. The education, in order to charitable, must relate to the public, and a trust created for education of the members of the family or descendant of a certain named individual are not charitable. This is something against the rule that we have seen in relief of poverty. Because in the relief of poverty, the members of the family, relations, all recognize as charitable trust. But here for the promotion of education, it's not that charitable trust, because it has no such benefit of public or section of the general public. The promotion of search for the truth and diffusion of useful knowledge, promotion, conferences and discussion, foundation and maintenance of conference centers and reading rooms for the general use among the members or others are object directly relating to the education. Then education is just to do the study or just to do the research, not like that. It is beyond that. Even the construction of conference hall, promotion of conferences, promotion of discussion and foundation and maintenance of conference centers and reading rooms, also part of education. Now we will move to the trust for the advancement of religion and maintenance of religious rites and practices. As we have seen in Pemsel, definition refer the trust for advancement of religion. And also we have seen United Kingdom Charities Act 2011. It also provides that advancement of religion. But in our trusts ordinance, section 99 provides that in addition to that, not only the advancement of religion but also maintenance of religious rites and practices. Then our scope in Sri Lanka, our scope is wider than the English scope. The trust for the maintenance of religious rites and practices may be invalid in England, but here it is valid in Sri Lanka. The inclusion of extra words in section 99 was perhaps intended to widen this category because Buddhism, Hinduism and Islam, which are practiced in Sri Lanka, are heavily ritualistic. But in Christianity there may be less or there may be no religious practices and rites and practices. Therefore, it is not permitted in England. A charitable or the religious endowment, in order to be charity in the legal sense, will have to be for the purpose of public nature, in other words, the benefit of the community or some part of it. That we have seen already. When the beneficiaries of the trust constitute general public or section of the public as distinguished from private individual, and when the trust is meant to perform a public charity, it is public charitable trust. The House of Lords in Gilmore versus Coates held that the requirement of public benefit is not satisfied and the trust will fail as charity if the trust is created for performance of private ceremony. That was the English case. But in Sri Lanka, Fernando versus Subramaniam, in that case, the Gilmore case was cited in Sri Lanka. That was the one and only case where the English case cited in Sri Lanka in relation to the promotion of religion and maintenance of religious rites and practices. In Fernando versus Subramaniam, a trust was created by Hindu testator, desirous of my soul's attainment of salvation, for the performance of religious ceremony. Pulle J. held that the facts in two cases were very different and therefore Gilmore case was not relevant authority. Now here the issue is like, if there's a private ceremony in any religious place, if the public also are able to participate there, then it should be charitable trust, because public also getting some sort of benefit there. But there are private ceremonies which may be held in a separate time with only the family members or the relations. The special puja in that time, special puja in that time. Therefore, no one other than the relations are participating there. In that case, it is not a charitable trust, it is a private trust, because we can't decide whether it is a private ceremony or public ceremony. Even the private ceremony, if it is conducted in front of all the general public, that may be charitable trust. But if it is if the private ceremony is conducted in a separate time, the unique and specified time other than the general time, then only the relations or individual who can participate there, then it can be categorized as private trust. That purely private religious service are not charitable has been confirmed. Purely private religious service. Now the thing is here, there is a service that is only for family members, the special time given, then only the family members attending those ceremony. In that case, it is not a charitable trust. That's very clear, because there is no such public benefit at all. But we will see here the contrast between this case, Cren Clark case, and Ree Hetherington case, which was in Ree Hetherington case, the service could be conducted either in public or private. The service could be conducted either in public or private. Then if it is in public, then the general public also benefited. If it is in a private, then general public can't be, or they can't attend those ceremony or the service. Then the judge was entitled to take the benignant view of the gift and assume that they would be held in public. As much as possible, court will take the lenient view in relation to the advancement of religion. Therefore, as much as possible, court try to give lenient view of the gift. But in the Grand Clark case, on the other hand, evidence clearly indicated that the service were conducted in private. So there is no room for the benignant assumption where the facts were clear, though it was also held on the facts that service were merely ancillary, and so the gift as whole was upheld as charitable. This case appears also to recognize the faith healing as charitable within the heading of charity. Even though it is under the heading of charity, but we must see whether there is a public benefit requirement is satisfied. If the public benefits requirement or the requirement of public benefit or requirement of section of the public benefit must be there. If it is not there, then it is not a charitable trust, but it is a private trust. English authorities regarding the element of public benefit have not generally been even cited in local decision except in Fernando case. The trust for observing various ways, Hindu festival days, for the bathing of idols and offering eatable to deity on the festival days, for keeping oil lamp burning in the temple, it is in the Buddhist temple also, and for performing ceremonies at the Hindu shrine, or for the maintenance of Buddhist rites. All these things are observing various ways of different religious practices. But the thing is, if the general public also permitted to participate in that one, in those ceremonies, then it should be interpreted as charitable trust. It was stated in this case, it was stated that the religious endowment is one which has for its object the establishment, maintenance, worship of idol and deity and other object or purpose of subservient to the religion. A charitable endowment is one which has its object benefit to the public or of mankind. CIT versus Jamal Muhammad Sahib case. In this case, it was said that there might be a private trust for the religious purpose, but there can't be no private charitable trust. That's very important here. I would like to emphasize this point here. There can't be a private charitable trust. Either it must be a private trust or charitable trust. Because if it is a charitable trust, it should fulfill those two qualification or criteria, like it is for the charity and it is for the benefit of public. Then it is a charitable trust. But if it is not, then it is a private trust. There is nothing known as no private charitable trusts. Bihar State Board of Religious Trust versus Palat Lal. It was said that if endowment is not intended to benefit the general body of worshippers, but only to the members of the family specified in individual, it is a private endowment, private trust at all. It's very clear idea here. The trust is not intended to benefit the general body of worshippers there, but it is only for the members of the family or specified individual. Then there is no second word, that's the private trust. But where the beneficiaries are not members of the family or a specified individual, then the endowment can be regarded as public, intended to benefit the general body of worshippers. Now the issue, again another issue we must discuss here. Now, private ceremony, public ceremony. Sometimes it may be a ceremony in private temple and public temple. Again, there's an issue in private temple and public temple. Public temple is where the considerable portion of the public or section of thereof has the beneficial interest. A gift for the purpose of a temple must therefore benefit the public. Then that's a public temple. If anything given to the public temple, that's the charitable trust, because the public attending those ceremonies as a right, then it is known as charitable trust. The main characteristic of the public temple is that it is intended for the use of public at large or specified class who are entitled the right of worshipping in it. Then how to identify whether it is a public temple or private temple? Sometimes it's very difficult to identify whether the temple is public or private temple, because there are so many people attending ceremonies, but still it is known as private temple. There are temples in Sri Lanka. Then we must identify what are the criteria we can apply, what are the requirements that we can apply to identify whether it is whether the temple is private or public temple. That's we can see here in brief. The origin of the temple, the manner in which its affairs are managed, the nature and extent of the gift received by it, expenses of the temple being met by public contribution, rights exercised by devotees in regard to the worship therein, consents of the manager and consents of the devotees themselves as to the character of the temple are factors that go to establish whether the temple is public or private temple. Then if the ceremony intended to hold in a public temple, there is no second word, that's known as charitable trust, because it is satisfying the requirement of public benefit. At the same time, if there is a ceremony or there's a performance of ceremony in the private temple, then that must be a private trust, because there is no such benefit of public. That is one of the tests we can see. Therefore, in relation to these performance of ceremonies, we must be very careful. First thing, we must see whether it happens in private ceremony or the general ceremony, the public ceremony. If it is scheduled to be a private ceremony in a specific time, only the relations are attending such ceremony, then that's known as private ceremony and also private trust. But it is a private ceremony again, but it happens in a general time or general hours or general service allocated in a specified time every day, then the general public also permitted to participate in that one, then it should be recognized as public or charitable trust. Even though the both cases private ceremony in specific hours, no one is participating other than the relation, then that's a private trust. Again private ceremony, but the public also can participate in that ceremony, then that's known as charitable trusts. Here finally we will see the Narayanan, Bhagavan, Raho, Gosavi, Balaji Vale versus Gopal Vinayak Gosavi. The Supreme Court of India held that vastness of the temple, that's again we are trying to define which is known as public temple. Here the Supreme Court held that vastness of the temple, mode of its construction, the longer use of public as of right, grant of land and cash by rulers, taken along with other factors that we have already seen, were consistent with the public nature of the temple. Then in addition to that, we have seen list of matters to identify the temple, whether it is a public temple or the private temple. In addition to that, now we must see vastness of the temple, mode of its construction, who has constructed this one. Then we must see whether they have received anything from the government, that's the ruler. Any contribution from the government, then in that case it should be public temple. Anything happening, any puja, any ceremony, whatever it is, any performance of puja or any performance of ceremony in the public temple, that should be treated as charitable trusts. Then we have done now, up to now, what we have studied. Simply we have studied now the first place we have seen the trust for the relief of poverty. Second, we have seen advancement of education and knowledge. Third one, we have seen advancement of religion and maintenance of religious rites and practices. The first one, relief of poverty, we have seen is an exception to the general rule of public benefit. But at the advancement of education and knowledge, that's not an exception, but we must follow the general rule. But in addition to that, in the case of knowledge, advancement of knowledge, that should be a research work. In the research work, there are some conditions that we have seen. The object of the research must be useful, and the outcome of the research must be given to the public. And we have seen the religion, advancement of religion and maintenance of religious rites and practice, as we have seen in United Kingdom in Charities Act 2011 does not have that maintenance of religious rites and practices, whereas in Sri Lanka the Trusts Ordinance provides that advancement of religion, not only that but also the maintenance of religious rites and practices. Then in the religion we must see private ceremony, public ceremony. Private ceremony in private time, private ceremony in public time. And also we have seen the private temple and public temple. Also we have defined and how to recognize whether the temple is private or public, that we have seen. Now the time has come to conclude these lectures today, but in the next lecture we will see trust for any other purpose beneficial or of interest to mankind. That we will see next time. Then we will stop with this one. Thank you very much.